Okay, good morning, class. Today I'm going to be dictating jury charge from 160 to 190. So let me give you some words that come out. You've got South Michigan Avenue, murder in the second degree, reckless manslaughter. You've got criminally negligent. You have Washington, D.C. You have February, provoked passion manslaughter, provoking irresistible, South Michigan Avenue. And so let me write some of these words down for you. You've got, so manslaughter is final MS with an asterisk, okay? Final MS with an asterisk. Sorry, y'all, let me just change these batteries, sorry. And you've got, so final MS with an asterisk is manslaughter. And then you've got second degree murder is SMD. S final MD without an asterisk. You've got murder in the second degree is MUFRD. MUFR. Let me look up murder in the second degree. Just a minute, I think it is one. And then you've got MUKD with an asterisk, MUKD with an asterisk, okay? Murder in the second degree. Washington, D.C., you can stroke in one stroke. WARB, DZ, Washington, D.C., WARB, DZ. You have, avenue is just AV. Avenue is AV. And you have presumption of innocence is PRUNS, PRUNS. Burden of proof is BRP, initial BR, final P. And this is going to be at 160 for 5 minutes, okay? The court particularly addresses you, ladies and gentlemen of the jury. The defendant is charged in the information with committing the crime of second-degree murder at the approximate location of South Michigan Avenue in Washington, D.C. on or about February 18, 1993. The defendant has pleaded not guilty. The information is a mere accusation against the defendant, and it is not in itself any evidence of the guilt of the defendant, and no juror should permit himself or herself to be influenced in any extent, however slight, against the defendant because or on account of the filing of such information. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless after considering all of the evidence you are then convinced about or that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. The mere number of witnesses appearing for or against a certain proposition does not in and of itself prove or disprove that proposition. You may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness or part of it or none of it. You have heard a witness who has testified as an expert. You are not bound by the testimony of an expert. His testimony is to be weighed as that of any other witness. It is entirely your decision to determine what weight shall be given to his testimony. The prosecution and the defendant have stipulated to certain facts in this case, and you were so instructed about these stipulations during the trial. A stipulation renders unnecessary the presentation of any evidence to prove those facts, and the jury must regard those facts as conclusively proved. The effect of a stipulation is to make the stipulated facts true for the purpose of trial. The elements of murder in the second degree are: 1, that the defendant, 2, on or about February 18, 1993, at the approximate location of South Michigan Avenue, Washington, D.C., 3, knowingly, 4, caused the death of another person, 5, without the affirmative defense, and instruction number 15. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove each of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the second degree. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged, if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of second-degree murder, as charged in the information in this case, necessarily includes the lesser offenses of reckless manslaughter, provoked passion manslaughter, and criminally negligent homicide. The elements of reckless manslaughter are: 1, that the defendant, 2, in the District of Columbia, at or about the date and place. Okay, and so District of Columbia, let me give you that. It's DK twice with an asterisk? Yes. District of Columbia, DK twice with an asterisk. Initial D, final K. And then you have prosecution is PRGS, initial PR, final GS. You have facts and circumstances, F long ARK, like that, FARKZ. You have if you find is FUF and D, FUF and D. If you find, let me give you irresistible, irresistible. No, yes, okay. And then you have accusation is accusation. Or accusation, okay? No? There it is. Accusation, 3 strokes, okay? And this is going to be 170, you all. Five minutes. The court particularly addresses you, ladies and gentlemen of the jury. The defendant is charged in the information with committing the crime of second-degree murder at the approximate location of South Michigan Avenue in Washington, D.C. on or about February 18, 1993. The defendant has pleaded not guilty. The information is a mere accusation against the defendant, and it is not in itself any evidence of the guilt of the defendant, and no juror should permit himself or herself to be influenced to any extent, however slight, against the defendant because or on account of the filing of such information. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless after considering all of the evidence you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. The mere number of witnesses appearing for or against a certain proposition does not, in and of itself, prove or disprove that proposition. You may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness or part of it or none of it. You have heard a witness who has testified as an expert. You are not bound by the testimony of an expert. His testimony is to be weighed as that of any other witness. It is entirely your decision to determine what weight shall be given to his testimony. The prosecution and the defendant have stipulated to certain facts in this case, and you were so instructed about these stipulations during the trial. A stipulation renders unnecessary the presentation of any evidence to prove those facts, and the jury must regard those facts as conclusively proved. The effect of a stipulation is to make the stipulated facts true for purposes of the trial. The elements of murder in the second degree are: 1, that the defendant, 2, on or about February 18, 1993, at the approximate location of South Michigan Avenue, Washington, D.C., 3, knowingly, 4, caused the death of another person, 5, without the affirmative defense and instruction number 15, after considering all the evidence, if you decide that the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove each of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the second degree. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of second-degree murder, as charged in the information in this case, necessarily includes the lesser offenses of reckless manslaughter, provoked passion manslaughter, and criminally negligent homicide. The elements of reckless manslaughter are: 1, that the defendant, 2, in the District of Columbia, at or about the date and place charged, 3, recklessly, 4, caused the death of another person, 5, without the affirmative defense and instruction number 15. The elements of provoked passion manslaughter are: 1, that the defendant, 2, in the District of Columbia, at or about the date and place charged, 3, knowingly, 4, caused the death of another person, 5, under circumstances where the act. Okay, and then let me write some words for you. Okay, so you have under circumstances, or maybe it's under the, it's under circumstances, so you can't use that. You have offense, O-F-N-S, offense. You have, I don't think there's a brief or affirmative defense. You have stipulation is stipulation. You have testified, T-E-F, come back D. T-E-F, come back D. Contradict is K-R-K-T with an asterisk. K-R, initial K-R, final KT with an asterisk. You have proposition. I know some people write PROPGS if you like that. And you have permit, PERMT, permit. On account, no. Account is KT. No. I just stroked it out, on account. And then you have influenced, convecti. Okay, influenced. This is going to be at, oh, common sense is KMNS. KMNS, we got the O. And this is, oh, for or against, you all. For or against is FORNGS with an asterisk. Okay, FORNS with an asterisk. Sorry, you all. Number of is NUFRM. NUFRM, okay? 180. The court particularly addresses you, ladies and gentlemen of the jury. The defendant is charged in the information with committing the crime of second-degree murder at the approximate location of South Michigan Avenue in Washington, D.C. on or about February 18, 1993. The defendant has pleaded not guilty. The information is a mere accusation against the defendant, and it is not in itself any evidence of the guilt of the defendant, and no juror should permit himself or herself to be influenced to any extent, however slight, against the defendant because or on account of the filing of such information. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless after considering all of the evidence you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. The mere number of witnesses appearing for or against a certain proposition does not in and of itself prove or disprove that proposition. You may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness or part of it or none of it. You have heard a witness who has testified as an expert. You are not bound by the testimony of an expert. His testimony is to be weighed as that of any other witness. It is entirely your decision to determine what weight shall be given to his testimony. The prosecution and the defendant have stipulated to certain facts in this case, and you were so instructed about these stipulations during the trial. A stipulation renders unnecessary the presentation of any evidence to prove those facts, and the jury must regard those facts as conclusively proved. The effect of a stipulation is to make the stipulated facts true for purposes of the trial. The elements of murder in the second degree are: 1, that the defendant, 2, on or about February 18, 1993, at the approximate location of South Michigan Avenue, Washington, D.C., 3, knowingly, 4, caused the death of another person, 5, without the affirmative defense, and instruction number 15. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove each of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the second degree. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged, if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of second-degree murder, as charged in the information in this case, necessarily includes the lesser offenses of reckless manslaughter, provoked passion manslaughter, and criminally negligent homicide. The elements of reckless manslaughter are: 1, that the defendant, 2, in the District of Columbia at or about the date and place charged, 3, recklessly, 4, cause the death of another person, 5, without the affirmative defense, and instruction number 15. The elements of provoked passion manslaughter are: 1, that the defendant, 2, in the District of Columbia at or about the date and place charged, 3, knowingly, 4, cause the death of another person. 5, under circumstances where the act causing death was performed under a sudden heat of passion, which was 6, caused by a serious and highly provoking act of the intended victim. 7, affecting the person sufficiently to excite an irresistible passion in a reasonable person. So passion is just P-A-G-S, passion, P-A-G-S. You've got Vatha, T-H-A-T, Vatha. You have homicide is H-D-Z, homicide, H-D-Z. You have, if you decide, F-U-D-Z, if you decide, maybe you have to put the asterisk in. You've got, no, it doesn't come out. You have determine is derm, D-E-R-M. Conclusively is conclusively. The effect, I don't know why you can't write the T-E-F-K-T and then just enter it. The evidence, T-E-V-D, the evidence. You have I think in and of itself, N-A-F-T-S, in and of itself. And this is going to be at 190, you all. The court particularly addresses you, ladies and gentlemen of the jury. The defendant is charged in the information with committing the crime of second-degree murder at the approximate location of South Michigan Avenue in Washington, D.C. on or about February 18, 1993. The defendant has pleaded not guilty. The information is a mere accusation against the defendant, and it is not in itself any evidence of the guilt of the defendant, and no juror should permit himself or herself to be influenced to any extent, however slight, against the defendant because or on account of the filing of such information. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless after considering all of the evidence you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proved beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. The mere number of witnesses appearing for or against a certain proposition does not, in and of itself, prove or disprove that proposition. You may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness or part of it or none of it. You may have heard a witness who has testified as an expert. You are not bound by the testimony of an expert. His testimony is to be weighed as that of any other witness. It is entirely your decision to determine what weight shall be given to his testimony. The prosecution and the defendant have stipulated to certain facts in this case, and you were so instructed about these stipulations during the trial. A stipulation renders unnecessary the presentation of any evidence to prove those facts, and the jury must regard those facts as conclusively proved. The effect of a stipulation is to make the stipulated facts true for purposes of the trial. The elements of murder in the second degree are: one, that the defendant, two, on or about February 18, 1993, at the approximate location of South Michigan Avenue, Washington, D.C., 3, knowingly, 4, caused the death of another person, 5, without the affirmative defense in instruction number 15. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove each of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the second degree. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of second-degree murder as charged in the information in this case necessarily includes the lesser offenses of reckless manslaughter, provoked passion manslaughter, and criminally negligent homicide. The elements of reckless manslaughter are: one, that the defendant, two, in the District of Columbia, at or about the date and place charged, 3, recklessly, 4, caused the death of another person, 5, without the affirmative defense in instruction number 15. The elements of provoked passion manslaughter are: 1, that the defendant, 2, in the District of Columbia, at or about the date and place charged, 3, knowingly, 4, caused the death of another person, 5, under circumstances where the act causing the death was performed under a sudden heat of passion, which was 6, caused by a serious and highly provoking act of the intended victim, 7, affecting the person sufficiently to excite an irresistible passion in a reasonable person. Okay, and so I was going to give you on or about, I wrote it earlier, NORBT, NORBT, okay, on or about. So we'll get ready for your test, you all. I'll start with your 180 number 1. Okay, so we have your 180 jury charge test number 1. Proper names you have District of Columbia, and remember DK twice with an asterisk, okay? DK twice with an asterisk is District of Columbia. Initial D, final K. This will be, it's called murder manslaughter. 180 jury charge test number 1 for 5 minutes, you all. Oh, cap court, when you can replace judge in the sentence. Here we go. The court particularly addresses you, ladies and gentlemen of the jury, that one of the important elements of provoked manslaughter is that there was no interval between the provocation and the killing sufficient for the voice of reason and humanity to be heard. Another important element of provoked passion manslaughter is that it is without the affirmative defense in instruction number 15. The court further addresses you, ladies and gentlemen of the jury, that the elements of criminally negligent homicide are: 1, that the defendant, 2, in the District of Columbia, at or about the date and place charged, 3, caused the death of another person, 4, by conduct amounting to criminal negligence, 5, without the affirmative defense in instruction number 15. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every material element of any lesser included offense which is necessarily included in any offense charged in the information. The law never imposes upon the defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in your verdict. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the crime charged or of a lesser included offense, you should find the defendant not guilty of the offense which has not been proved, and you should so state in your verdict. While you may find the defendant not guilty of any or all of the crimes charged or of any lesser included offenses, you may not find the defendant guilty of more than one of the following offenses: second-degree murder, reckless manslaughter, provoked passion manslaughter, criminally negligent homicide. A crime is committed when the defendant has committed a voluntary act prohibited by law, accompanied by a culpable mental state. Voluntary act means an act performed consciously as a result of effort or determination. Culpable mental state means knowingly, recklessly, and with criminal negligence, as explained in this instruction. Proof of the commission of the act alone is not sufficient to prove that the defendant had the required culpable mental state. The culpable mental state is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. A person acts knowingly with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such circumstance exists. A person acts knowingly with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. Concerning the charge, in this case, certain words or phrases have a particular meaning. The following are the definitions of these words or phrases. Cause means that act or failure to act which in the natural and probable sequence produced the claimed injury. It is a cause without which the claimed injury would not have been incurred. Homicide means the killing of a person by another. Person means a human being who had been born and was alive at the time of the homicidal act when referring to the victim of a homicide. The evidence presented in this case has raised an affirmative defense. The prosecution has the burden of proving the guilt of the defendant to your satisfaction beyond a reasonable doubt as to the affirmative defense, as well as to all the elements of the crime charged. After considering the evidence concerning the affirmative defense with all the other evidence in the case, if you are not convinced beyond a reasonable doubt of the defendant's guilt, you must return a verdict of not guilty. Ladies and gentlemen of the jury, the court further addresses you on instruction number 15, which is an affirmative defense to the crimes herein charged. It is an affirmative defense to the crimes of second-degree murder, reckless and provoked manslaughter, and criminally negligent homicide that the defendant used deadly physical force because 1, he reasonably believed a lesser degree of force was inadequate, and 2, had reasonable grounds to believe and did believe that he or another person was in imminent danger of being killed or of receiving great bodily injury, or 3, that the decedent was committing or reasonably appeared to be about to commit assault. Ladies and gentlemen, the court will address you that diminished responsibility due to self-induced intoxication is not a defense to second-degree murder. Ladies and gentlemen of the jury, we will take a recess at this time. I must give you this warning. Do not discuss the case with anyone until the case is over. I have not seen any of the people that usually cover cases for the newspapers and television, but I don't know that a case of this kind might draw some publicity, and I would ask that during the course of any recess, if you hear anything about the case or see anything, that you not pay any attention to anything about this case in any of and then we have your second 180 jury charge. Proper names you have none. I do see court. Cap it when you can replace judge in the sentence, okay? This is going to be 180 test number 2, jury charge for 5 minutes. Ladies and gentlemen of the jury, the evidence in the case consists of the sworn testimony of all the witnesses, all exhibits which have been received in evidence, and all facts which have been admitted or agreed to. In determining the facts, you must consider only the evidence received at trial. Evidence offered at the trial and rejected or stricken by the court must not be considered by you. Statements, remarks, arguments, and objections by counsel and remarks of the court not directed to you are not evidence. You are to consider only the evidence in the case and the reasonable inferences from that evidence. An inference is a deduction or conclusion which reason and common sense lead the jury to draw from other facts which have been proved. When the attorneys on both sides agree as to the existence of a fact or a fact has been admitted, the jury must regard that fact as proved. Evidence may be either direct or circumstantial. Circumstantial evidence is the proof of facts or circumstances from which the existence or non-existence of other facts may reasonably be inferred. All other evidence is direct evidence. The law makes no distinction between the effect of direct evidence and circumstantial evidence. The weight of evidence is not necessarily determined by the number of witnesses testifying to a particular fact. Any finding of fact you make must be based on probabilities, not possibilities. It must not be based on surmise, speculation, or conjecture. You must not be influenced by sympathy or by prejudice for or against any party in this case. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You should take into consideration their means of knowledge, strength of memory, and opportunities for observation, the reasonableness or unreasonableness of their testimony, their motives, whether their testimony has been contradicted, their bias, prejudice, or interest, if any, their manner or demeanor upon the witness stand, and all other facts and circumstances shown by the evidence which affect the credibility of the witnesses. If you believe that any witness has willfully testified falsely to any material fact in this case, you may disregard all or any part of the witness's testimony. The burden of proof is upon the plaintiff to establish its case by a preponderance of the evidence. The burden of proof is upon the defendant to establish any affirmative defense by a preponderance of the evidence. Burden of proof means the obligation resting on the party or parties who assert a proposition to establish the same by a preponderance of the evidence presented in this case, regardless of which party may have produced such evidence. A fact or proposition has been proved by a preponderance of the evidence if, considering all of the evidence, you find it to be more probably true than not. If a party fails to meet its or her burden of proof, or if the evidence weighs so evenly that you are unable to say that there is a preponderance on either side, you must resolve the question against the party who has the burden of proof and in favor of the opposing party. You have heard evidence in the case from witnesses who have testified as experts. The law allows experts to express opinions on subjects involving their special knowledge, training, and skill, experience, or research. You, ladies and gentlemen, shall determine what weight, if any, should be given their testimony as with any other witness. The original written instructions are a part of the court record. You are not permitted to write any notes on the original instructions or to deface them in any way. The original instructions and the exhibits are to be returned to the court at the conclusion of your deliberations. The bailiff will now escort you to the jury room. Upon reaching the jury room, you are to select one of your members to be the foreperson of the jury. Your foreperson will preside over your deliberations. Your foreperson and all the other members of the jury must sign whatever verdict you reach. You must all agree on your verdict. When you have agreed upon your verdict, your foreperson should notify the bailiff that you have agreed upon a verdict, but the verdict should not be revealed to the bailiff. The foreperson shall keep the verdict forms, these instructions, and the exhibits until instructed further by the court. These instructions contain the law that will govern you in this case. No single instruction states all the applicable law. All the instructions must be read and considered together. You must not be concerned with the wisdom of any rule of law, regardless of any opinion you may have as to what the law should be. It would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in the instructions of the court. The court did not in any way and does not by these instructions express any opinion as to what has or has not been proved in the case, or to what are or are not the facts of the case. In your deliberations, you must be governed by these instructions, which must be considered by you as an integrated whole. In your deliberations, you may consider only the evidence presented at. Okay, and we'll get ready for your 160s. So we have 160 number 1, jury charge. You have Mark, Dale, and John. Okay, this is going to be then 160 jury charge test number 1 for 5 minutes. Ladies and gentlemen of the jury, we now come to that part of the case where we must make a differentiation in your minds as to what the difference is between homicide, murder, and manslaughter. First of all, homicide is not a crime. Homicide is the killing of one human being by another human being. Some homicides are not criminal by their very nature. For example, if a child is playing with a loaded gun with another playmate and the gun fires and kills the playmate, this is considered an accidental killing and is not criminal in nature. Some homicides are not criminal because the killing was done in self-defense. For example, if a robber enters a liquor store and pulls a gun on the attendant and tells him to empty the cash drawer and threatens to shoot the attendant, if he doesn't comply, the attendant, if he is armed, may shoot the robber in self-defense. Murder is the unlawful killing of a human being by another human being with malice aforethought. Malice aforethought implies the fact that the murderer may not have thought about the killing beforehand, but death did result from the murderer's acts or deeds. Malice aforethought means that the murderer was in an evil state of mind when the acts were perpetrated. Malice aforethought includes a situation where there is serious intent to harm an individual. For example, Dale hits Mark on his body and head with a baseball bat with the intent of inflicting serious bodily harm, intending only to hurt Mark, not kill him. If Mark dies of these injuries inflicted by Dale, Dale is guilty of murder. Malice aforethought includes the intentional killing of another human being without some legal justification, sometimes called murder in cold blood. Malice aforethought includes the performance of an act that has a high risk of serious bodily injury to another or even death. For example, John stands on a freeway overpass and starts shooting at random and passing vehicles, not trying to strike anyone in particular. If a bullet strikes a passing motorist and kills someone, John is guilty of murder because of the strong probability that such an act would or could result in the serious injury of death or death of an individual. Malice aforethought is present if a murder is committed during the course of a felony action. For example, if a fire is started in a warehouse by arson, the arsonist is guilty of murder. If the night watchman burns to death in the fire, this rule applies to any murder committed during a dangerous felony, which includes rape, robbery, arson, and burglary. This is called the felony murder rule. Malice aforethought is present when a police officer is killed in the line of duty while attempting to arrest a suspect, even if the resisting suspect did not intend to kill the officer. He is still guilty of murder. Ladies and gentlemen of the jury, let's talk now about the degrees of murder. In our state, murder is broken down into two categories: murder in the first degree and murder in the second degree. First degree murder is subject to more severe penalties, sometimes death in the gas chamber. To be proven first degree murder must be deliberate, willful, and premeditated. First degree murder must be caused by a weapon, poison, or torture. First degree murder includes any murder committed during the course of a felony. Second degree murder is defined as murder without premeditation. The suspect killed an individual, but the killing was not preconceived. In second degree murder, the suspect may have seriously intended to harm the victim and death resulted, but the plan was not originally to kill the victim. The difference between first degree murder and second degree murder comes down to the suspect's true intent at the time the crime was committed. Based on the evidence presented to the members of the jury and the court, that decision has to be made. Now that we have covered the definition of murder, let's go on to the definition of manslaughter. Manslaughter is the unlawful killing of one human being by another human being without malice aforethought. There are two types of manslaughter. Voluntary manslaughter is defined as an intentional killing where malice aforethought is not present. For example, if a man comes home and finds his wife being beaten by their drug-crazed son, and the man murders his son, the killing, although still unlawful, is usually reduced from murder to manslaughter. On the other hand, if the father comes home and finds his son beating his mother and separates them, and then 3 or 4 days later murders his son for the act, he is charged with murder because he deliberately plotted to kill his son for this act. Involuntary manslaughter is an unintentional killing. With involuntary manslaughter, the suspect is criminally negligent and does not possess any. That was a little tough. And then we have your 160, number 2. You have count 1. Let me see if there's anything else. Capitalize both, Roman numeral 1. And that's it, you all. This will be 160, jury charge number 2 for 5 minutes. Circumstantial evidence is evidence that, if found to be true, proves a fact from which another inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that facts be proved by direct evidence. They may be proved also by circumstantial evidence or by a combination of direct and circumstantial evidence. Both direct and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance on which the interference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular account permits 2 reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation that points to the defendant's innocence and reject that interpretation that points to his guilt. If, on the other hand, one interpretation of this evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. The specific intent or mental state with which an act is done may be shown by the circumstances surrounding the commission of the act. However, you may not find the defendant guilty of the crime charged in count 1 unless the proved circumstances are not only 1, consistent with the theory that the defendant had the required specific intent or mental state, but 2, cannot be reconciled with any other rational conclusion. Also, if the evidence as to any specific intent or mental state permits 2 reasonable interpretations, one of which points to the existence of the specific intent or mental state and the other to its absence, you must adopt the interpretation which points to its absence. If, on the other hand, one interpretation of the evidence as to the specific intent or mental state appears to you to be reasonable and the other to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence or who may appear to have some knowledge of these events. Neither side is required to produce all objects or documents mentioned or suggested by the evidence. Evidence that at some other time a witness made a statement or statements that is or are inconsistent or consistent with his or her testimony in this trial may be considered by you not only for the purpose of testing the credibility of the witness, but also as evidence of the truth of the facts as stated by the witness on that former occasion. If you disbelieve a witness's testimony that he or she no longer remembers a certain event, that testimony is inconsistent with a prior statement or statements by him or her describing that event. Every person who testifies under oath is a witness. You are the sole judges of the believability of a witness and the weight to be given the testimony of each witness. In determining the believability of a witness, you may consider anything that has a tendency to prove or disprove the truthfulness of the testimony of the witness, including but not limited to any of the following: the extent of the opportunity or ability of the witness to see or hear or otherwise become aware of any matter about which the witness testified, the ability of the witness to remember or to communicate any matter about which the witness testified, the character and quality of that testimony, the demeanor and manner of the witness while testifying, the existence or non-existence of a bias, interest, or other motive, the existence or non-existence of any fact testified to by the witness, the attitude of the witness toward this action or toward the beginning of the testimony, a statement previously made by the witness that is consistent or inconsistent with his or her testimony, the character of the witness for honesty or truthfulness or their opposites, discrepancies in a witness's testimony or between a witness's testimony and that. Okay, you all, so that's it for your jury charge. They were a little tough. Maybe the 180s were better. See how you did. Type them up, read your notes, enter words into your dictionaries, and you all have a wonderful day. And don't forget to access at the very beginning of your week where it breaks it up into speed building. Don't forget to access your discussion board, okay? I need everybody to engage in that. Very important. So it'll be part of your grade next semester, okay? So please, please access that. Have a wonderful day, you all.